I'm thrilled and honored to have with us today Professor Siobhán Mullally, the UN Special Rapporteur on Trafficking in Persons, especially women and children. Mullally is the established professor of human rights law and director of the Irish Centre for Human Rights at the School of Law, National University of Ireland, Galway, and serves as the president of served as the president of the Council of Europe Group of Experts on Action Against Trafficking in Human Beings, GRETA, from 2016 to 2018. Professor Mullally has worked with international NGOs and UN agencies in many parts of the world. She's the recipient of numerous research awards for work relating to gender equality, migration and refugee protection, human trafficking and migrant workers, including from the Irish Research Council, European Commission, Irish Aid, and the International Bar Association. She has too many accomplishments for the short time we have here, but I'll just note that she was recently selected for the Irish British Academy. So congratulations on that as well. So Professor Mullally will talk to us today about labor rights, human rights, and feminist lawyering beyond the limits of criminal justice responses to human trafficking. So thank you so much for joining us today, and the floor is yours.
Thank you very much, and thank you very much for the kind introduction, and thank you for the opportunity to participate in today's event. First of all, I just want to congratulate Hilla and all of the team who've been involved in the drafting of the Alternative Action Plan and the report and the work that has led to today's seminar. I'm delighted to be part of this, and I guess one question that I would have straight from the outset is who forms part of the dominant anti-trafficking approach and who doesn't? And in particular, I'm interested in reflections on the work of the Special Rapporteur, the Special Procedures mandate holders, and how we might or might not have contributed to that limited vision of anti-trafficking work. So it would be really interesting to talk further with you on that. Apologies, I'm having to speak on my phone because my webcam decided not to work on my laptop. So if I'm moving around, that's just why that is the case. I want to respond to the comments made, and also to draw on some of the critique in the Alternative Action Plan and the concern that law, practice and policy on human trafficking has remained within this very narrow individualistic focus and primarily a criminal justice response, with the dominant focus really on trafficking for purposes of sexual exploitation and much less to concerns in relation to trafficking for purposes of forced labor and the wider context of labor exploitation. I think it's just interesting to note immediately as a response that I think there are many actors, many civil society actors, many in NGOs, and including some actors within the international human rights law system trying to take an alternative approach, trying to raise attention in relation to the importance of addressing socioeconomic rights violations, failures in terms of labor rights protection, failures in terms of protections of the rights of migrant workers and their families, racial injustice that is often at the root of discriminatory approaches to labor rights protection or to the rights of migrant workers and their families, or to protection of socioeconomic rights more broadly. But those approaches don't gain traction in the same way that the criminal justice focus does, or the individualized focus on access to compensation or victim identification, provision of shelters and assistance, which are absolutely critical in terms of addressing the situation of trafficked persons and their families. But as Hilla said, what we are missing is addressing the wider structural violence and structural human rights violations that lead to situations in which people are in difficult and risky circumstances and at risk of becoming victims of trafficking. So our prevention focus is much more limited than the prosecution focus, for example. So a few things on that. The Anti-Trafficking Action Plan and the research of TrafLab has highlighted the roots of anti-trafficking action in the Palermo Protocol and in work that has developed since then. I think to overcome that limitation and the limitations within the Palermo Protocol itself, which is relatively weak in terms of prevention and certainly quite weak in terms of victim assistance, we need to be able to draw on the whole range of international human rights law. And certainly in my work as Special Rapporteur and my predecessor also, we consistently try to not only draw on the Palermo Protocol, but the whole range of international human rights, international labor law, international humanitarian law, and criminal law where that is relevant. But I would say, again, that is constantly a challenge to point to the relevance of the Third Convention, the Covenant on Economic, Social and Cultural Rights, the general comments and practice and concluding observations of all of the treaty bodies, including of the Committee on the Rights of Migrant Workers and their Families, the Committee on the Rights of Persons with Disabilities, the Committee on Enforced Disappearances. Some victims of trafficking may also be victims of enforced disappearances, but many victims of trafficking, particularly for purposes of labor exploitation, are also covered by the whole range of UN human rights treaties, which potentially give strong protection to trafficked persons if applied in a non-discriminatory fashion, but that is not always the case. And again, the attention given by different treaty bodies varies, and it varies by state. And that is often a consequence of limited capacity and limited capacity of civil society within that particular state who may not be raising trafficking issues. And I think it also raises the question around what are trade unions doing in relation to prevention of trafficking and raising awareness of risks of trafficking. And many trade unions are very active in prevention of trafficking, in trying to highlight the risks, in trying to ensure strengthened protections. But here again, I would see that fragmentation that we see within international law between international labor law, international human rights law, anti-trafficking law, that contributes to those gaps in oversight, in monitoring, in enforcement, so that much of the work, anti-trafficking work done at international level is channeled through UNODC as the primary UN agency engaging on anti-trafficking action. So although we have the Protocol of 2014 to the Forced Labour Convention, and many ILO treaties and standards that are very relevant to the prevention of trafficking and protection of the rights of trafficked persons, we don't see the ILO coming to the fore in terms of recognition of its role in anti-trafficking, or being given the same platform, if you like, or same profile in terms of recognizing its role and the role of its treaties and standards in prevention of trafficking. We do have the ILO Convention on Worst Forms of Child Labour now universally ratified. And there again, that is critical in terms of prevention of trafficking. But many of the ILO treaties and standards on agricultural work, for example, on fisheries, are either not widely ratified or not comprehensively enforced. Also of particular relevance, of course, to Israel is the ratification of the Council of Europe Convention on Action Against Trafficking in Human Beings and the work of its treaty monitoring body, Greta, the group of experts. And they have had a particular focus on trafficking for purposes of forced labor and labor exploitation, and tried to expand the guidance and analysis of prevention work and protection work in that field. But I would say that sometimes Greta, the group of experts, has also been criticized as not having a strong enough focus on trafficking for purposes of sexual exploitation, or not having a strong enough gender focus. And that's interesting because, in fact, I would think if you look at the work of the group of experts, they have tried to expand the gender focus to highlight the whole range of gender inequalities that can lead to heightened risks of trafficking, including failures of identification of men and boys as victims, or recognizing heightened risks for LGBT persons. In my work, just very briefly, some of you may be familiar with the work of the special procedures, others may not. We have particular tools available to us, communications to states. Those may be what are called other letters, commentaries on legislation and policy. They become public after 48 hours, or allegation letters in relation to specific situations or urgent appeals. Those become public after 60 days, though we can issue a press release or statement about them, but not giving the details. So we try to engage with states in that way. It's a soft law tool. They're not binding as such, but states are required to engage with and comply with the mechanisms and procedures of the Human Rights Council. On thematic reports, these are reports that are presented from my mandate to the Human Rights Council and to the General Assembly, Third Committee. And that is an opportunity to engage in an interactive dialogue with states and to highlight particular issues. We have country visits, we engage in multilateral fora, etc. So in relation to thematic reports of my mandate, I would highlight, for example, the one presented last week on the agricultural sector, the use of human rights due diligence tools, and the links across with the Sustainable Development Goals. We've also looked in some detail at supply chains, at labour migration, and in all of those highlight the importance of partnership with civil society and trade unions. On supply chains, for example, I just issued what's called an other letter, so public after 48 hours, commenting on the EU draft directive and the limitations in relation to its proposals around corporate due diligence, human rights due diligence, and environment due diligence. In that, similar to the French law, many high-risk enterprises and businesses will fall outside of its scope of application. There's also questions around a limited gender focus and a lack of attention to the requirements of partnerships with civil society, trade unions, and human rights defenders. In relation to actual communications, these are often responsive. So again, are responding to complaints. The focus tends to be very much on individualized responses. In my work, I've tried to highlight the potential of the communications to also address group situations where there are broader structural problems in relation to visa situations or absence of inspections or oversight and protections. So we've had quite significant communications to Guatemala in relation to the palm oil sector, to Serbia, China, and Vietnam in relation to migrant workers in Serbia, primarily coming from Vietnam. And those also went to a number of business enterprises, some of whom that were registered and incorporated in China, hence the engagement there. We've had communications, I'm just talking about recent ones now, but to Saudi Arabia and Vietnam in relation to migrant domestic workers in Saudi Arabia coming from Vietnam, and raising questions around the role of recruitment agencies and intermediaries, as well as the gaps in terms of protection in Saudi Arabia, the difficulties in relation to monitoring of the terms and conditions of employment, as well as conditions of work, and in some instances, physical violence. We've also had other letters to the UK in relation to the migrant domestic worker visa regimes, and to India in relation to its pending anti-trafficking legislation, which has a very strong focus on rescue and rehabilitation, rather than the rights of trafficked persons or prevention focus. The mandate can also act as an amicus in court proceedings. So I've done that in proceedings in the UK, the European Court of Human Rights, at the International Criminal Court, and recently in a Rule 39 urgent application procedure in relation to the so-called partnership with Rwanda and returns or transfers rather of asylum seekers to Rwanda from the UK. In relation to the amicus intervention in the UK Supreme Court, we're still waiting on the judgment, but that related specifically to migrant domestic workers in diplomatic households, and the whole question around the scope of diplomatic immunity. An intervention to the Court of Appeal related specifically to the non-punishment principle in anti-trafficking law in the UK. In terms of my thematic work, what I would say is in terms of some of the work done to date, yes, it has tended to focus on questions around individual remedies and access to justice. In linking in with the labour migration context, I have been part of the regional reviews of the Global Compact on Migration and participated recently in the International Migration Review Forum. And as part of that, I did try to highlight the importance of safe reporting, the non-punishment principle, but also repeatedly in all of my statements have emphasized the importance of expanding pathways to safe, orderly and regular migration as a way of combating and eradicating trafficking, so Objective 10 of the Global Compact on Migration. And you do see that concern in a number of statements made by states. Bangladesh, for example, has been very active in the review process around the Global Compact and engaging also with the Global Plan of Action on anti-trafficking and emphasizing the importance of expanding pathways to safe migration, as well as to then residence and stay. But again, this is where less attention is given, even in reporting, media reporting, in the follow-up, and of course in implementation. So in the report that I presented last week on the agriculture sector, I emphasized the nature of informal work in agriculture, the limited scope and resourcing of labour inspectorates, the reliance on temporary, seasonal and migrant workers, the appalling conditions in which they work, the risks faced by their families, the tied nature of visas, the difficulties in terms of changing employer or employment sectors, the abuse to which they are vulnerable because of the temporary nature of their employment and the circular migration, and then also particular concerns in relation to the rights of rural women, insecurity of land tenure, increase in child labour in the last 3 years, a reversal of the trend that we had been seeing in terms of a reduction in child labour globally and the risks of trafficking that brings. So there is an attempt to address those wider structural issues and issues around labour rights protection and the rights of migrant workers and their families in particular. But it remains difficult to progress the recommendations. And I guess one of the strategies for me in organising a side event around that and in following up is to try to engage different types of actors. So the International Congress of Trade Unions, but also the Food and Agriculture Organisation, FAO, the International Fund for Agriculture Development, as well as the International Labour Organization and ILO. So to try to get different actors thinking about the importance of preventing trafficking. On the gender dimension, I think it's also important to recognize the difficulties that arise in ensuring identification of men and boys as victims of trafficking, because they appear to be less vulnerable. Their accounts of exploitation are sometimes perceived as less credible. Men and boys who are migrants in irregular situations are often perceived as being more threatening rather than being vulnerable and victims of exploitation. And that gender dimension also impacts on limited identification of women and girls. So only particular stereotypes who fit into the stereotype of a trafficked victim are recognized as such. LGBT plus persons of diverse gender identities may also be particularly at risk of exploitation. In our consultations on the agriculture report, for example, it was pointed out to us that a person's identity, gender identity, or sexual orientation maybe used against them in a threatening way, in a coercive manner, making them more vulnerable to exploitation in particular work sectors. Particularly if that may be a challenge in terms of their community or where they're living, or if there's a silence or invisibility around their gender identity or sexual orientation. And a particular gap in the agriculture sector, of course, is the limited presence of trade unions, much more limited opportunities for collective organizing and collective bargaining. So some NGOs, some more informal workers' associations and workers' committees, but not a strong presence of trade unions or other kind of collective organizing and collective bargaining. And I think a cross-cutting problem that is recognized and is addressed, I think, in the Anti-Trafficking Action Plan is just the much more limited attention given to socioeconomic rights. So in international law, we focus on the crisis moments. As Hilary Charlesworth said quite a long time ago, international law has this focus on crisis. That means that human rights are returned to the sender, if you like. The human rights actor, the human rights advocate becomes the humanitarian actor. So we move into this mode of rescue and rehabilitation, but much less attention given to the everyday socioeconomic rights violations, the everyday failures in terms of labor rights protections. And that international law of the everyday gets much more limited attention, much more traction with states, is much more difficult in terms of securing enforcement and support, including from media, including from civil society, including from the philanthropists who support anti-trafficking action. So is interested in the recommendations and measures and tools that are highlighted in the Anti-Trafficking Action Plan, the role of bilateral labour agreements, the recognition that there can be often very limited enforcement, that implementation on the ground in practice is not always followed through following the adoption of a bilateral labour agreement, that we need much more expansive supply chain due diligence to overcome the limitations in terms of scope and application of current measures, and that we really need to take seriously the commitment to and the legal obligation of non-discrimination in protection of labour rights, in terms of protections of socioeconomic rights. And on partnerships, here, for example, in my mandate, I've been part of letters and statements highlighting Israel's designation of 6 Palestinian civil society groups as terrorist organizations. And here in particular of concern was the impact that that would have on the prevention and advocacy work of the Agricultural Workers Committee and the Union of Palestinian Women, on Defence for Children International, all of whom have really important roles, as well as Al-Haq and the other organizations, but have really important roles in preventing exploitation of Palestinians and promoting their rights without discrimination. And that obligation of partnership with NGOs and with civil society is found in the Council of Europe Convention, for example. So it's something that Greta, the group of experts, has always emphasized. Also resourcing and support and an enabling environment for civil society. We've seen that also in drawing on the Palermo Protocol. There's also a requirement of trying to, it's much weaker, but engaging with and working with NGOs in particular. But that enabling environment for civil society and for trade unions is absolutely critical to prevention work. And again, it's something that I and other mandate holders have highlighted in the EU context, for example, where we've seen increasing criminalization of human rights defenders supporting and assisting migrants. And that is a trend that we see globally. So again, just to conclude, I'm very happy to see this action plan, the focus on prevention, and I'd be interested in talking further to you about next steps on that. Certainly in my work, as I said, I've been trying to emphasize the importance of expanding safe pathways to migration, including ending tied visas and looking at the rights of migrant workers and their families, not just looking at the migrant worker as a labor unit, and strengthening workers' rights, the role and scope and competence of labour inspectorates, the implementation of labour standards, and the role of trade unions and collective bargaining. So trying to overcome what was described as the dominant anti-trafficking approach, and to bring those alternative approaches, which I think many are trying to work to bring to the fore, but not receiving attention or not gaining traction in the way that other kinds of anti-trafficking approaches are doing. So thank you very much.
Thank you very much, Professor Mullally, for this very, very interesting talk. I think definitely the Special Rapporteur, especially in recent years, has been a site for expansion of the tools, at least in terms of recommendations and engagement with governments. But as you said, traction is always challenging. I will say that within the Israeli context, we have here some of our strong collaborators from government, and we're always grateful to the fact that they are first willing to come and listen to our criticism, but also to very seriously engage in it. And I think this dialogue between civil society and government, and I see Dina Dominitz here, we're always very, very grateful for the openness, even if we're sometimes frustrated of the lack of traction with some of it, but I think it's definitely a process. And I think the existence of such a sphere is definitely key for at least maintaining some optimism about this. And so I would like to open the floor for questions for Professor Mullally. You can just raise your hand if somebody wants to ask their question. I feel we're a community here. We can definitely people can just talk. So if anybody wants to have a question for Professor Mullally, if not, I will go ahead and ask one. Yes, Catherine Babineau.
Hi, Professor, and hi, Hila. It's so wonderful to be here with all of you. And thank you so much for that really interesting set of comments and presentation. I just have a quick question about how you envision the role of migrant sending states, in particular within this kind of within these alternative approaches to anti-trafficking efforts, particularly centering on labor. How do you think about the role that migrant sending states play, particularly since so much of the activity that you describe is happening sort of, workers are sort of pulled into situations of forced and unfree labor, sort of before they arrive in states where they might be, working or laboring. And so I just wanted to kind of to see if you had any other thoughts on that. Thanks.
Professor Mullally, would you like us to take some more questions, or would you like to answer?
I can respond. Yeah,
Yes.
very quickly. Thank you very much for the question. I think this is a really important point. So we see many attempts to try to prevent trafficking for purposes of forced labor, to try to prevent exploitation of migrant workers, starting in the countries of origin, the sending states. So for example, again, just to give a concrete example, last week I presented a country report in Tajikistan following a country visit in December. And Tajikistan is a sending state. Many migrant workers were traveling to the Russian Federation for work, and also to Gulf states. And a whole program was developed around pre-departure orientation, provision of information to migrant workers prior to departure. And there have been some examples of bilateral labor agreements, again, to try to prevent exploitation. I raised some concerns in relation to how those were enforced in practice, of course, the follow-up and monitoring in countries of destination. But these are very important measures. One concern was the lack of a gender dimension, so lack of attention, for example, to domestic work and what was happening with regard to migrant domestic workers and care workers, and an insufficient focus in that work. But I think a broader question is also, and this is something that's also raised in the TrafLab work, is around the role of recruitment agencies and recruitment intermediaries and difficulties in terms of monitoring and licensing of those. And that is, it is critical that that monitoring and licensing is sufficiently rigorous and is consistently enforced, because they play a key role, obviously, in ensuring the protection of migrant workers. But unfortunately, I think, and this is not specific to one state or jurisdiction, but we often see difficulties in relation to corruption and complicity of government officials or border officials with practices of recruitment agencies or recruitment intermediaries that lead to exploitation, including trafficking. So there's an important role there in terms of the regulation, the licensing and monitoring of recruitment agencies and recruitment intermediaries. We also need to, really think about labor externalization policies that we see, for example, in some jurisdictions in East Africa and elsewhere, whether that is a good way of addressing questions around access to employment and decent work. And if it is an actual government policy and practice, is enough being done to ensure that the rights of workers are protected and enforced. And it's critically important that the response is not a restrictive one, not shutting down migration or limiting opportunities, but is one that really takes seriously expanding those opportunities, which may be really important opportunities for work and employment and career development, particularly for women. But we need to ensure that there is enforcement and follow-up monitoring of the labour rights protections, including in countries of destination. And embassies and consular officials have important roles there as well. And the monitoring and highlighting of what's happening in countries of destination is critical. But despite some incremental reforms, we continue to see reports of appalling labour rights abuses and also of trafficking for purposes of forced labour, which is often linked sometimes to sexual exploitation and other forms of abuse as well. Thank you.
Thank you. Virginia Mantovalu.
Hi, thank you, Hila. I'm trying to find the special rapporteur on my screen. Thank you very much for here. Thank you very much for your talk. I found it incredibly insightful and interesting. I wanted to ask you about two things that you raised. First of all, you mentioned the fragmentation of the various bodies and international human rights institutions. And I wondered if you could tell us a little bit about whether there is any possibilities and any particular concrete interactions, whether they collaborate at all, whether they meet up and discuss. I don't know, institutions like your role now, yourself, and the Human Rights Committee, bodies of the ILO. Is there any action like that? Do you talk to each other? Do you find that what your findings feed into findings of, say, the Human Rights Committee or the European Court of Human Rights, etc.? The second question I have, so the first question is about how all these international bodies interact and whether you find that there is some cross-fertilization, I think it was called at some point in the past. On the other hand, I wanted to ask you about how receptive are policymakers, politicians, because there is a backlash now against human rights as fashionable in some literature, on the left, on the right, everywhere. And in the UK, obviously, the government is, they are not big on human rights protection. So I wondered whether in your role, you find that policymakers are receptive when you draw their attention to human rights violations in the areas of your mandate, or if you have also a more general sense about receptiveness of national governments by other institutions like your role, like other special rapporteurs.
Thank you very much, Virginia, for that. On fragmentation, yes, I mean, there are, of course, different parts of the UN system and different bodies, whether it's treaty bodies or the charter-based bodies or international courts, talk to each other, but it's very much dependent on individual effort and trying to make those links and repeatedly make those links. And I think that's a challenge for all kinds of reasons. But I think certainly the dominant role in relation to anti-trafficking action has been sort of ceded to UNODC in particular. And they have a particular role around the Palermo Protocol, the Conference of the Parties, and the work around that. The ILO, since the 2014 protocol, has been doing more, but it's just not as systematic. So it's, and yes, I talk to treaty bodies, but that's dependent on making a specific effort to do that and with limited capacity and resources. To the European Court of Human Rights, I've done an amicus intervention. We don't have the Grand Chamber judgment yet. I've done the Rule 39 application. But yes, special procedures, mandate holders do make interventions, do engage in different fora. But it's a constant effort to try to do that. Whereas I think when it comes to trafficking for purposes of sexual exploitation, it's more easily understood, the relevance. However, again, there I would say that it's even there, I would say that the focus is very much on individualized violations also. So it's quite difficult to, there's a significant gap in relation to responses from humanitarian actors and responses to conflict situations and recognizing risks of trafficking for purposes of sexual exploitation that affect large groups and are much more widespread and affect larger numbers of people than the individualized human rights violations that there tends to be a focus on. So that's a broader challenge. So cross-fertilization or integrated approaches, certainly in my reports and in the communications, I consistently draw on the standards of international human rights treaties and international labor standards. But that requires me constantly doing that. The kind of default is just refer to the Palermo Protocol and the Office of the High Commissioner recommended principles and guidelines. So it's a constant push to try to ensure that broader engagement. The backlash and receptiveness, some countries are more receptive, others, completely ignore the comments and recommendations and communications or respond, but in a relatively general way without really engaging. And others are very concerned, but sometimes, particularly around supply chain due diligence or where large business enterprises are engaged and implicated, there can be concern around losing traction with them, or there can be deference to them rather than to an intervention from a mandate holder. So it depends. In some contexts, there's a willingness to engage, and we also try to make recommendations to other international actors or UN agencies that perhaps they need to be providing more support or assistance or strengthening their work in a particular area as well to provide assistance and support. So it really varies depending on the jurisdiction and the context and the particular issues.
Thank you. So we'll take one final question from Janie Trank.
Hi, thank you so much, Professor Mullally, for your wonderful talk. I had two quick questions. One, sort of building on Virginia's question about fragmentation and the different actors working in this space. I wondered if you had any insights on reactions to the Cedaw general recommendation on trafficking. I'll just say that I thought it was helpful that it included some very specific provisions on sort of non-sexual labor trafficking, but also quite disheartened by the turn it took between the draft and the final version of the general recommendation that seemed to weigh in favor of a broader approach to sex trafficking that would seek the abolition of sex work altogether. So I'm wondering if that has had an impact on reactions to the sort of human rights approach to trafficking. Because I know that, part of the reason we have why some of the human rights protections were so thin, anemic in the trafficking protocol was because of that fight over sex work versus prostitution and its relationship to trafficking. And I worry that fight is rearing its ugly head again in light of the Cedaw general recommendation. And the other quick question, which you can address or not address, is you mentioned philanthropies, and I'm wondering what you've seen in the way of the role of philanthropies in policymaking, and whether or not you think it's a good thing, bad thing, just a reaction to philanthropies in trafficking policymaking. Thanks.
Thank you very much for those questions. So on Cedaw General Recommendation number 38, that was finally adopted shortly after I was appointed, and I had participated, as many did, in the discussions around the draft and made a submission. But the final recommendation was published in, and as you say, I think many were surprised at some of the language and references in it. And I think that has been problematic in that maybe there's a reluctance to engage with other parts of the general recommendation. It has quite useful recommendations on the labor context, on the business context, on migration more generally. But there is a concern around some of the language that is used and the reference, for example, to the 1949 convention. And I think that links into a broader concern around what maybe this focus on what does combating demand mean, and is combating demand only relevant in the context of sex trafficking? Isn't it also relevant in the broader labor context? And also, what does it mean? Does it only mean the criminalization model in terms of criminalizing clients? So yeah, that continues, of course, to be a dominant debate. And it's there are certain states, of course, that take that approach, but also do engage more broadly. And do engage more broadly on questions around humanitarian conflict settings, and to some extent also on the rights of migrant workers and the risks of labor exploitation. So it's of course been there since the drafting of the Palermo Protocol, and for many decades and much longer before that. So that persists, and I think for some civil society actors, that means there's a reluctance to engage with Cedaw or the general recommendation as a whole, even though other parts of it may be quite useful. But But I'm not sure that that impacts more broadly on other parts of the human rights system, because in fact, I think only there is a relatively small number of treaty bodies that systematically engage with questions around trafficking. CERD does, CRC, ISISCR less so, the Migrant Workers Committee does as well, and the Human Rights Committee and ICCPR less so. But again, as I said, I think that's very much dependent on what's brought to them in reports and civil society submissions and shadow reports, and then specific concerns raised in relation to states. And it would be really good if there was, you know, if my office, for example, had capacity to systematically engage with upcoming reporting processes and lists of issues in a timely way, to highlight trafficking issues. But that's a broader concern. In relation to philanthropy, yes, there's a significant philanthropic movement, obviously, involved in anti-trafficking action. And of course, you've done a lot of work on that, so I think you're probably in a better position to comment than me. But again, yes, philanthropists have particular agendas and particular objectives, and that can shape what becomes dominant in the voices around anti-trafficking action. There are also philanthropists working more broadly, including on the rights of migrant workers and labour rights. But again, I would say sometimes it just doesn't get as much traction or visibility as other kinds of work. Thanks.
Thank you very, very much.
Maya Niesna. Maya